Good morning.
Good morning, Your Honor. Thank you very much. John Marshall for the Bar Council. May it please the Court. This is a bar discipline case that comes before you on Bar Council's appeal from a term suspension order of a 3-year suspension entered by a single justice. The case is a reciprocal discipline case. The respondent's resignation from the Florida bar was accepted by the Florida Supreme Court as a result of his conviction in federal court in Florida for conspiracy to possess cocaine with intent to distribute. Our position on this appeal is that the 3-year suspension ordered by the single justice is markedly disparate, as too lenient, and cannot stand. Our position also is that the appropriate sanction in this case would be to accept the Florida resignation as a Massachusetts reciprocal discipline.
So meaning effectively disbarment, I mean, in practical terms?
Yes, that gets into the waiting period, and that would be the effect of that. And our position is that that is not an inappropriate result, given the factors involved in this case, the circumstances involving the crime involved, the fact that the respondent did not report the...
So why, okay, I guess my question is why would we impose resignation as opposed to disbarment from your perspective?
From our perspective, Your Honor, the answer to that question is simply that the Florida court made a decision to accept the respondent's resignation as a disciplinary resignation and did not enter an order of disbarment or did not reject the petition, believing that disbarment was the appropriate sanction. There is some, according to this court's Watt decision involving a Rhode Island reciprocal, there is some leeway, some deference is given to a sister jurisdiction's decision on sanction. And because of that, our position in this case always has been that the appropriate result would be to accept the resignation.
No, what is the, in Florida, what is the, is there a period beyond which, or within which, the respondent cannot apply for readmission in Florida?
Yes, in fact, it's specifically in the order.
Yeah.
The respondent was given leave to apply for readmission to the Florida bar 5 years after the date of the...
Okay, but for us, isn't disbarment 8 years?
Disbarment is 8 years, yes.
So it's
that is correct.
resignation. Resignation in lieu of...
Disbarment and resignation are 8 years. Indefinite suspension is 5 years. Term suspensions are the length of the suspension.
So in terms of comparability, is this closer to an indefinite suspension?
It is,
given what
yes,
happened in Florida.
It is because of the 5-year waiting period in Florida. I'd like to point out two things in that. First of all, in Florida, it's a 5-year waiting period for readmission to the Florida bar as opposed to reinstatement to the Florida bar.
Take the bar exam?
That's a difference exactly. I think the bottom line difference between those two is that you would have to take the bar exam again. We consider that to be a more onerous burden on the attorney. Secondly, as we have expressed in our brief, we believe that an 8-year waiting period is appropriate given the circumstances of the case. On the other hand, this court has discretion, has authority under Section 18 on reinstatements in Massachusetts to vary the waiting period in appropriate circumstances. So in this situation, if it were the court's judgment to vary the waiting period to 5 years in recognition of the fact that it was 5 years in Florida, that would not be in violation of the reinstatement rules. We believe it's not necessary in this case, but would understand the court doing that, but believe that that would be the minimum waiting period that should be applied to this case.
So I'm just technically, procedurally, I'm a little confused. Okay. What is it that you're recommending we do?
We're asking that you accept the Florida resignation as a reciprocal sanction in Massachusetts.
So accept
what does that
the resignation.
That means that the resignation, that means that the respondent is deemed to have resigned in Massachusetts, which is a disposition of a case which is specifically permitted by our rules under Section 15 of Rule 4:01. Under our rules, the resignation would require,
To have resigned as of when?
as of the effective date of the order. There's
That's 2012 or something, right?
the effective date of the order that you,
Of
that would
Judge
be
Lenks.
entered.
Of our order.
I'm sorry, it would be as of the effective date of Judge Lenks' order. You're right, because that has already been entered and he has complied with the order.
Okay, so let me ask you this. I think maybe our rules deal this, but if one is, can one impose a resignation? I mean, resignation usually involves a voluntary, I mean, an act, you saying, I resign. So
Yes.
can one impose a resignation on somebody?
Yes, for two reasons, Your Honor. This court handled a very similar case a few years ago, matter of Ngobini. It's cited in our
Yes.
brief.
Yes.
It was a Connecticut resignation, and we sought resignation in Massachusetts, and the respondent objected, and he fought it all the way. And the case came before the full court, and the court determined that resignation was appropriate, and the order that was entered, I think it was to the effect of the respondent's Connecticut resignation is accepted as a reciprocal sanction in Massachusetts.
Even though the waiting period, if you will, may be different than the state from which it's coming?
Yes, I don't believe there was any, I don't remember there being any discussion in the Ngobini case about the waiting period, and I don't know offhand whether there is a difference between Massachusetts and Connecticut resignations.
So you're saying that when somebody resigns from the Florida bar, we can say, we accept your resignation and deem it to be a resignation from the Massachusetts bar?
Yes.
Even when he's saying, wait,
Yes.
I'm not resigning from the Massachusetts bar? I don't
Yes.
wish to resign?
Thank you for reminding me, Your Honor. There were two responses to that same question, and the second response is that the function of reciprocal discipline is, if appropriate, to import into Massachusetts proceedings what has happened in the sister state. And in this case, the operative event that happened in Florida is that the respondent chose to resign from the Florida bar as a disciplinary resignation as a result of the federal criminal conviction. So that can be imported under the reciprocal discipline rules, whether or not the respondent is now saying, I don't agree to that in Massachusetts. The situation would be no different if, for example, the respondent had stipulated to discipline in Florida as a result of the criminal conviction. If he had stipulated to the facts and agreed to a sanction in Florida, that would be considered reciprocally in Massachusetts, and it would not be within the respondent's right to come here and say, well, you can't accept that because I'm not agreeing to those facts in this proceeding.
But isn't there a difference between saying I agree I did it versus I agree as to that I resigned because of, I mean, this is also a long time ago. I mean, isn't it more honest for us to do an indefinite suspension with the same sanctions employed by the Florida bar? Isn't that a more honest way of doing it as opposed to accepting a resignation that he hasn't given?
I respectfully disagree, Your Honor, although I certainly would not object to that outcome. It's up to the court to decide whether or not to accept the resignation. We're here because the single justice in this case not only decided not to accept the resignation, but decided to impose a 3-year suspension. And for all of the reasons cited in our brief, we believe that that was disparate. An indefinite suspension would not be disparate for the usual sanction in Massachusetts for a felony conviction. The usual sanction is an indefinite suspension or disbarment.
Okay, so help me to understand. If we did an indefinite suspension, that's all we did, he could seek to be readmitted in 8 years.
5 years.
5 years.
5 years,
Which is the
yes.
same length of time he could in Florida.
Same length of time for him to apply for readmission in Florida, yes, that's correct.
But don't we also, though, have case law that at the end of the day, it's what we would look as to what would be the appropriate level of discipline here? I mean, in other words,
Yes, that is
if
the-
Florida,
Yes.
I mean, this gets to the point of, if Florida, if we would say, yes, it would be appropriate to have resignation in lieu of disbarment.
Yes.
But that's our resignation in lieu of disbarment, which is an 8-year waiting period.
Yes.
But we don't think it's appropriate resignation in lieu of disbarment if it's a 5-year waiting period. Where do we go?
You accept the resignation and order a 5-year waiting period, as is your right under Section 18.
But I may have misunderstood Justice Batsford's question, but let's say in Florida, spitting on a courthouse floor results in mandatory disbarment. It's just disbarment.
Yes.
And here, spitting on a courthouse floor, I'm making this up.
Yes.
Is 6 months suspension. We would probably go with a 6-month suspension, wouldn't we?
Yes, that is correct.
So
And-
what is the comparable sanction for the kind of punishment that was meted out in the federal court in Florida?
The comparable Massachusetts discipline, our position is, would be an indefinite suspension or disbarment. In our brief, we have explained that the starting point is cases like Finneran, which basically say that indefinite suspension or disbarment is appropriate for any felony conviction. We believe that that would apply to this case for the reasons cited in our brief, and we have argued in our brief that based upon the additional factors, his failure to report the sanctions from Florida and his continuing practicing law to a certain extent would warrant disbarment as opposed to indefinite suspension. But yes, that's what would be required by Massachusetts precedent.
Counsel, your time is up.
Thank you very much.
Thank you.
Good afternoon. May it please the court. Sarah Holden here today for the respondent, Michael Burnbaum, who I have here with me. The issue on appeal to be decided is whether the 3-year suspension imposed by the single justice is markedly disparate from other cases in the Commonwealth with similarly situated facts. And the respondent's position is that the 3-year suspension...
No, can we figure that one out, what the
Got some
buzzing is?
feedback.
Sorry for the interruption. We had some technical problems up here.
Are we all set?
Yes, ma'am, we are.
The respondent submits that the 3-year suspension imposed by the single justice is appropriate under the circumstances of this case, and then it should be upheld. When you look at 401 Section 16, reciprocal discipline isn't automatic. The court has discretion to impose reciprocal discipline that mirrors the discipline that was imposed in the foreign state, or to adjust it based on case law in the Commonwealth.
But you've got a plea of guilty to a felony occurring in the practice of law. So explain to me why 3 years is not markedly disparate?
The single justice relied on matter of gene in her opinion, which talked about the fact that there's a general principle that for felony cases, the usual sanction is an indefinite suspension or disbarment. But as is clear from the case law, both cited by the single justice in Gene and in Bar Counsel's brief, when you're talking about the subset of drug felonies, there's quite a variance in sanctions that are appropriate. It's not a singular result of just indefinite suspension or disbarment. So we have the matter of Gene case, in which Bar Counsel in that case argued that the usual sanction for a drug offense is a term suspension.
What were the facts of Gene?
Gene was, it was a drug case that didn't involve the practice of law.
Isn't that quite a big difference?
Yes, but in Gene, in the court agreeing with Bar Counsel that the usual sanction for a felony drug charge is a term suspension, they actually cited to the court case, which is a case that did involve the practice of law, in which the court ordered a term suspension. So the other two cases that were also cited, it's not clear from the decisions whether or not the underlying facts involve the practice of law or not. But they're certainly precedent for imposing a term suspension even when the underlying conduct involves the practice of law. And the 3-year suspension imposed by the single justice certainly fits within that range of appropriate sanctions for that conduct.
And the case that Jean relied on, which was, I think you said it was a drug offense that did involve the practice of law?
Correct, matter
What
of
was,
work.
what was the age, what year was that case?
I would have to check. I think it was I want to say 2000.
But it was in the 2000s?
Yes, I don't believe that it was an older case.
Okay.
Does the quantity of drugs matter here? I mean, we have 145 kilograms at issue. That's much larger quantity than we usually deal with.
I don't think it matters. I've not seen any distinction made amongst the cases. In this particular case, the facts that underlined the conviction dealt with the respondent acting as a conduit of information, not physically being involved in having that quantity of drugs.
Well, I understand, but it was, I think, is it fair to say it's precisely because he was an attorney and would be able to smuggle out a map from a prison that he was used as the conduit? I mean, doesn't that aggravate it considerably?
I think if you look at the case law where you have Quirk and you also have the case of Cohen, which I think Bar Counsel cited to in their brief, which was an indefinite suspension, which was an aggravated set of facts because you had an attorney that went into a secured facility and actually brought drugs into a secured facility. This was merely information that was passed along to the respondent.
Is that better?
I think that
Here
that's
is where the drugs, here is where 145 kilograms of drugs are hidden, so you can locate them. That's less egregious than I'm going to bring in a small quantity of cocaine for you to use or sell in the prison?
Yes, the court in Cohen did treat it as an aggravating factor, the fact that this is an illegal substance that's being brought into a secured facility as opposed to simply information.
In Quirk and in the other case you just mentioned. Cohen.
Correct.
At least as I understand it, the two respondents were themselves addicted. That's not the case here, is it?
That is not the case here, no. This isn't a personal addiction issue. Bar Counsel has taken the position that the court should order a reciprocal resignation in this case. We submit that the term suspension issued by the single justice is the appropriate sanction. But when you look at the case law, and this was discussed in the single justice's opinion, in order to impose a reciprocal resignation, the respondent typically in those cases either agrees to it or does not object to it. And the case of Ngobini, that we had discussed previously, in that case, the respondent argued that because there was no finding of fact, you couldn't impose reciprocal discipline at all. And the court found that even if you don't have a finding of fact or misconduct, that yes, you can have a reciprocal resignation imposed, and we don't dispute that. But when you look at the case law, the only time that it's imposed is when it's agreed to. It's not involuntarily imposed.
Well, but in Ngobini, it was not agreed to, right? I'm lost.
He was fighting the respondent in that case disputed whether or not you could
He could be
even
disciplined
have
at all,
resignation.
but he clearly did not
reciprocal
agree.
resignation.
He did not agree to a resignation.
No, he did not believe that that any reciprocal discipline could be imposed at all.
Right.
And the court said, no, we can impose reciprocal discipline, even if there isn't a finding of misconduct or fact, because you resigned in the foreign state. In imposing reciprocal resignation, it's not automatic. The court can take into account factors of the specific case in front of them. And in this case, we're talking about a resignation that occurred almost 14 years ago.
Yes, but he didn't report it.
That's correct, and that's not to excuse his failure to
And the single justice
report.
suggests that in 2011, he actually used the fact that he was still a member of the Massachusetts Bar in another pleading.
He had been at a very recently for a limited circumstance. The respondent had been practicing some federal law only. But when he resigned from the Florida Bar and was sanctioned for the underlying criminal conduct, he was in fact incarcerated, and during that time was undeniably out of the practice of law. And when we look to impose reciprocal discipline, we're looking to really protect the public's perception of the bar and to deter attorneys from misconduct. And we're not excusing his failure to report. He certainly had a duty to know the rules that governed his conduct. It wasn't something that was intentional. But an additional 3 years out of the practice of law, on top of the time that he's already been out of the practice of law, is sufficient to deter an attorney's failure to report.
He has never applied for readmission in Florida, is that
He
correct?
has not.
Although he could, no one disagrees, he could.
Oh, certainly he could. He moved from Florida. He had no ties there. He didn't intend to practice there. So there was no reason for him to have reapplied to Florida.
Do you think there's a difference in perception from your client's point of view between resignation and disbarment?
I think that in general, resignations are sometimes looked at differently than disbarment.
More favorably then? Less onerous then?
Potentially,
Just like the difference between indefinite suspension and disbarment?
potentially.
Okay.
Even though if you've got, depending on the amount of time that needs to pass before you can go in, yes, it might be viewed more favorably.
I think your
Thank you very
client
much.
wants to say something, actually. Give just a minute. I think
He wanted you to say something?
I think there's a note to you.
Oh.
I rest my brief. Thank you.
All right. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sing at Boston.